Hi everybody, my name is Pat Hogarty and I'm a professor of real estate here at Sacramento City College. And what we're going to be doing, this is going to be the last in our series of lectures on real estate contracts. And so far we've talked about the residential listing agreement and some of the forms that are involved in that contract, if you will. We've talked about the residential purchase agreement. We've moved on and talked about what do we do if we have a dispute between the buyer and the seller, and we've talked about mediation and arbitration, and in some cases just trying to negotiate. And also our guest Dave Tanner mentioned the fact that you may a solution might be to go to small claims court if it's especially a normal human being and it's less than $10,000. So now what we want to do, the last part, is talk about the role that Sacramento Association of Realtors would have in, if you will, a dispute resolution specifically in two different areas. One would be if the buyer or seller had a complaint, if you will, against their real estate agent, or in fact if a real estate agent had a complaint against another real estate agent. And then also we want to have some time and talk about some services that they provide in the area of mediation and arbitration, which is not part of the ethics resolution, but is part of trying to help people to resolve their issues. And again, I want to welcome back Dave Tanner. And again, I mentioned,
good to be here.
And Dave is the CEO of the Sacramento Association of Realtors. And we want to continue on with our discussion. We want to talk about, if you go to the Sacramento Association of Realtors website, you'll see a link and a website link or a menu item on there that'll talk about ethics complaint or dispute resolution. Dispute resolution. And in that link provides a lot of very valuable and helpful information. In fact, if memory serves me correctly, it explains the process, and it also provides the forms that would be necessary for the person bringing the action, the complaint, to the board that they would have to fill out to submit. So what I want to do is just take a minute and have you go through some of the steps. First of all, how does the process start as far as I'm upset with my real estate agent or my real estate broker and I want to file a complaint? How do I get that started? How does that process work?
Okay, well, all of this falls in the area at the association that we refer to as professional standards. And professional standards covers both the ethics issues and also the arbitrations. So somebody calls in and they would get referred to our professional standards administrator. And she would talk with them about what their issues are, the things that they're unhappy about, what somebody did, and she would advise them, whether that might be something that they might want to look at filing an ethics complaint about, or maybe they need to contact the Department of Real Estate if it's something serious, it's a violation of DRE regulations. They might need to go there. If they come to the Sacramento Association, we can only accept complaints for people that are realtors, which means that they're people that belong to a local association and also the California National Association. Only 1/3 of the licensees in the state of California are realtors. So there may be a lot of people out there that somebody has a complaint about, but we can't do anything about it because it doesn't fall within our jurisdiction because they're not a realtor. So they're not subject to the Code of Ethics. But then everybody that has a license is subject to DRE enforcement. So if it's something that looks like it's a DRE violation, we would refer them over there to file a complaint. But if they file a complaint with our association, then it's rather a cumbersome process. As you mentioned, there's a lot of forms and things on there. So we do have ways to help people. In the initial intake, they'll ask them if they want to talk to an ombudsperson. We used to call them ombudsmen, but now we have both men and women doing it, so we refer to them as ombudsperson. But it's somebody that they can talk to that is a licensee, that's an actual member, a practitioner in the field. They work in real estate every day. They can talk to them about it, and they can provide them ways in which maybe they can get it resolved other than just filing an ethics complaint. Maybe they can call and talk to the broker. Maybe they are reluctant to call and talk to the broker, but they'd like the ombudsperson to do that. The ombudsperson could call and talk to the broker and see if they can reach a resolution. A lot of times somebody does something that makes somebody unhappy, and really all they want is for somebody to say, "I'm sorry." Mm-hmm. And sometimes people are reluctant or don't recognize that somebody wants them to say they're sorry. Okay. So if somebody calls them and says, "You know, if you just call this person and tell them that you're really sorry that that happened," a lot of times that makes it go away. But what we're trying to do is we're trying to make sure that people that have complaints about Realtor members, that they get some satisfaction for what they're unhappy about. A lot of times, as I mentioned, it's not something we can do anything about because it may not be a violation of the Code of Ethics, and that's all that we can enforce.
Now, the Code of Ethics is what? Tell us real briefly what that...
Well, the Code of Ethics is published by the National Association of Realtors, and it's enforced by the local association. And it has 17 articles, which are things that a realtor is not supposed to do. But one of them says that the realtor must cooperate in this hearing process, and one says they must arbitrate disputes with other realtors. So there's really only 15 rules that are covered. So if it falls, but they are rather broad rules, so they cover a lot of things. If they violate one of those 15 rules, then an ethics complaint is appropriate. But it may be that what they did is something that is not a violation of one of those rules. Like the complaints that we get a lot frequently is that they just don't call them back. They call their office and they call the real estate office and they say that, you know, I'm having this problem, and nobody ever calls them back. That's not unethical. It certainly, in my opinion, is a bad business practice, but it's not unethical, so we really can't take an ethics complaint on that. But if they talk to an ombudsperson, they may be able to call that broker and get the broker to call the person back and get the issue resolved. And a lot of times that's all they're looking for. They're not really looking to have somebody punished or to even with them. They're just they want somebody to pay attention to them and resolve whatever it is that's bothering them.
Okay. Okay, so that's the first thing. So we have the intake, if we will. Intake is something that I guess we not only use there, but we use in the medical community, you know, where we get intaked into the hospital.
Right.
Just, if you will, maybe another term might be triaged. Kind of trying to make a decision on what way we should really go. In the hospital, it'd be send them to the operating room or send them home, and in this case, you know, turn them over to the I can't pronounce that.
Ombudsperson.
Ombudsperson, or file a complaint. So anyway, so let's say they file a complaint. Let's say as a result of this they file a complaint, okay, and they fill out all the paperwork. Okay, what happens before the hearing? And I guess there is a hearing. Okay, and so you'll have to tell us what the hearing is about, but what happens before the hearing is there? Paperwork gets submitted, or what goes on?
Well, there could be a hearing if we get to that stage. But what happens first is they file a complaint, and in the filing of the complaint there's a form that they fill out, and basically they just explain what it is that happened to them. And they check boxes saying that I think that what they did is a violation of this article, this article, this article.
So the articles, the ethics articles are in this form then?
And a brief description.
Okay.
And also when they get the package, they get a copy of the entire Code of Ethics, so they can read the article and say, yeah, I think that this applies.
Okay.
Like one of the articles, Article 1, says that a realtor shall put the interest of their clients first. So that's pretty broad. That can cover a wide range of things. Mm-hmm. But if the realtor gets in a situation where the client that they're working with thinks that they're representing the interest of the other party more than theirs, that's something they can file an ethics complaint on.
Okay.
So they file the ethics complaint. Then the ethics complaint goes to the grievance committee, which is a committee that we have, which operates kind of like the grand jury. What they do is they get the complaint in, They read the complaint and they say, if everything in this complaint is true, they're not making any judgment at all. If everything in this complaint is true, is that potentially a violation of one of the articles of the Code of Ethics?
Okay.
And if it is, then they look and make sure that the individuals cited the right articles, that they've named the right people. Once it goes through the grievance committee, if they decide that there's a potential for violation of Code of Ethics, then it goes to the Professional Standards Committee for a hearing. At that time, the realtor that they filed the complaint against is notified that the complaint has been filed. They're given a copy of the complaint. They have an opportunity to file their response to the complaint. And then once they have the complaint and the response, then an impartial hearing panel of 3 members of the Professional Standards Committee agree to meet and hold a hearing, and it's a full due process hearing. People can bring in witnesses, they can bring in evidence, whatever they want to support their claims, both sides. And then once they've done that, then the hearing panel will make a decision.
And does that decision by the hearing panel have to be unanimous, or in other words, does there, if there's, I understand there's 3 people on this panel. Does that
2 out of 3.
2 out of 3, so
Yes.
the majority rules.
Yes.
Okay. So, yeah, so you do the math. If one wants it and the other 2 don't, they essentially.
My experience, I've been sitting on hearing panels for 23 years now. They are almost always unanimous.
Okay.
Everybody that's on there is experienced in the Code of Ethics. They understand what the requirements are. There's rarely a case where it's something that's on the line where 2 think that it is or is not a violation and the other one doesn't.
Mm-hmm.
Most times it either is clearly a violation or it's clearly not a violation.
Okay. So let's say, for example, it's been found. You know, if it's not found as a violation, then the agent is not affected at all. Okay. If the agent is found to be at fault, then what action does the board then take? If they find that there is an ethics violation, what happens?
There's a wide range of actions that are available. Probably the minimal is they can put a letter of warning in the realtor's file. The second is they can issue a letter of reprimand, and that goes in the realtor's file. They can require them to go to training classes that are appropriate for whatever the violation was. It appears that some remedial training needs to be done. They can give them a monetary fine of up to $5,000. They can suspend their membership, or they can expel them from membership in the association.
Okay.
That does not affect their license at all. It doesn't even affect their ability to do business, because in the state of California you do not have to be a realtor to have access to the MLS.
Okay.
So if we expel somebody, they still can belong to the MLS and they can still sell real estate. So,
are you obligated to report your findings to the Department of Real Estate, or is that not an issue?
we refer findings to the Department of Real Estate if there's find that there's been a violation of the public trust resulting in substantial financial harm to the customer or the client.
Okay. And then I know that's a whole separate process. In other words, the person bringing the action has to file a complaint with the Department of Real Estate, and then they have their process that they go through, which could end up in the suspension of their license, right?
If we refer the complaint if the association refers the complaint because there's a violation of the public trust, then the Department of Real Estate can pick that up on their own. It's not really necessary that the complainant in the ethics hearing also serve as a complainant for DRE.
Oh, okay.
DRE can pick up our findings and carry it on their own. Once DRE is aware of any potential violation, then they can carry it forward without anybody having to make a complaint or continue the complaint process.
Okay. Okay. All right. So then this all hearing goes on, and then the agent is either they're okay or they're not okay. If they're not okay, then they can get everything from a verbal reprimand to a letter to a fine to, if you will, suspension, or from being a member of the realtor, which, by the way, as you mentioned, doesn't take their license away. That's a separate action by the Department of Real Estate.
Correct.
Which has their own process altogether, which can be, they can suspend the license, or they can limit the license, from what I understand, right? They can limit what the person can do. What kind of limits? What kind of limits could DRE possibly? Well, number one, they can take the license completely away, right?
Well, DRE has expanded powers now as of this year. Prior to this time, DRE, all they could do was suspend or revoke the license.
Okay.
If they revoke the license, then they can also authorize the individual to apply for a restricted license. But essentially that was all the discipline they had. Now DRE, in cases where they find that there is a violation of DRE regulations, but maybe it's not that serious that it warrants the whole hearing process and looking at suspension or revocation, Department of Real Estate now can fine an individual up to $2,500
Okay.
Per instance. And DRE also now has the ability to fine somebody that does not have a license if they're involved in licensed activities.
Okay.
So if somebody goes out, because I just had a complaint come to me yesterday about somebody that's out there acting as a real estate broker that has no license.
Which is
so Department of Real Estate, before all they could do is send a letter to them saying desist and refrain. Now they can send that letter, but they can also fine them $2,500. So it puts a little more teeth into Department of Real Estate discipline.
Okay.
But now it gives the ability for them to issue fines of up to $2,500 to a licensee, where previously maybe they would say, you know, we're not going to go through a whole hearing on this because we wouldn't want to suspend or revoke their license anyway. It's a pretty minor infraction. Now they can fine them $1,000 for doing it. So it's going to cause licensees, I think, to pay a little more attention to DRE regulations.
Right.
Because the potential for discipline is much greater now, I think. Okay. Although it has not been fully implemented by DRE yet, so we'll have to wait to see how that.
Yeah, you always have to kind of set a precedent and figure out what the first couple cases are going to be like as to how you're going to do it.
Right.
Okay, besides that process, we were talking before we started, if you will, this guest lecture, about the fact that Sacramento Association of Realtors also provides services in mediation and arbitration. And if you could explain that a little bit more and who's involved and how does that process work?
Yes, Sacramento Association of Realtors about 8 years ago sent a group of members through the Strauss Alternative Dispute Resolution Program administered by Pepperdine University. And so we've got these people that are highly trained. In fact, they have 40 hours of mediation training where you only have to have 32 hours to be a mediator for the Superior Court. So they're highly trained individuals, but they also are all members of the association. So they've got many years of experience in real estate transactions, so they really understand the subject matter that they're looking at. Mm-hmm. They're trained mediators, and they can mediate both disputes between realtors, but also between a member and the realtor, between a customer or a consumer and the realtor, if the consumer agrees to be bound by the rules. But SAR also, unlike most associations, SAR provides mediation services to disputes between buyers and sellers.
Okay. So
they can come to us. So in an earlier segment we talked about the cost of going to arbitration, say at JAMS, where it's $750 an hour. Mm-hmm. A buyer and seller with a dispute could come to the Sacramento Association and pay $250 each for up to 3 hours of mediation time.
Okay.
And from my experience, most of the mediations that we've had have been resolved within that 3-hour time. So it's a very economical way to resolve those disputes.
Okay. So that's what you're doing for the mediation. And again, so I almost look at mediation as being kind of like a counseling session kind of a thing. You know, you're trying to get...
In some ways.
You know, you're trying to get things to work out. Family counseling, marriage and family counseling. Arbitration, though, is a lot more, I don't know, we always think arbitration is a lot more serious. It's like, now we got the judge involved, okay? So let's go.
And in arbitration, at Sacramento Association, we only do arbitrations involving realtors.
Okay.
We do not do those with the public because of the potential exposure for legal issues. So if a buyer and seller end up with an arbitration dispute, they can't come to the association for that. They would have to go outside. But they could come to the association for the mediation.
Okay.
And very often we can make those disputes go away so they never have to go to arbitration.
So when you say the arbitration for the realtors, you're talking about when, you know, one realtor from one company and one from the other company has a dispute. Naturally, I think we talked about in the previous things, it has to be worthwhile, has to be a fairly substantial amount of money. I don't know what, I always have to ask, what's the cost?
Well, if they go to outside arbitration, it would have to be a substantial sum. But again, if they come to the Sacramento Association, it's only $250 on each side to have an arbitration hearing.
Okay, and the arbitration hearing would last?
As long as it takes.
As long as it takes, okay.
Yeah, whatever it takes. Although most arbitration hearings are done about an hour and a half or 2 hours. Okay. Regardless of how complex they are, there's, you know, it's a dispute between money. There's a limited amount of facts that can enter into determining who's entitled to receive the money. So we have those. But another program that we have at the Sacramento Association is if two brokers have a dispute and they file for arbitration, they pay $250 each to file the arbitration. But if they come into mediation voluntarily before the arbitration and they settle the case at mediation, we give them back $200 of their filing fee, each of them.
Okay.
So it only costs $50 to come in and get your dispute mediated.
Mm-hmm.
So it's a great way to resolve disputes between brokers when they're not able to do it on their own.
What kinds of complaints would one broker, you know, I mean, the reason why I ask this is because as a consumer you can see where, oh, I got mad at my real estate agent because they didn't tell me about that I need to bring in more down payment or the house roof leaked or whatever. But what in the world would two brokers, what would they have as a dispute that would have to?
The most common dispute between brokers has to do with commissions. Mm-hmm. And most of those have to do with the concept of procuring cause, which is a legal concept. It says that I was the person who caused that transaction to be put in motion. Okay. For instance, if I go out and I show you houses mm-hmm. all weekend, okay, and we find the house that you really like on Sunday afternoon, and you say, I need to think about that. And you go home and call your brother that's a broker in LA and have him write up the offer for you on the house that I showed you. In that scenario, I very likely might be found to be the procuring cause, and it might very likely might be my commission okay. that I'd be entitled to. So then my dispute would be with the broker in LA that got the commission at close of escrow. And in that scenario, the arbitrators might decide that I was entitled to the commission, order the other broker to pay me the commission because I was the one that helped you find the house.
Does that happen very often?
It depends. A lot of it is market driven. Okay. A lot of it has to do with how many, in a market like we had 6 years ago when everybody was working with 20 buyers and they were just going crazy trying to keep up with the buyers. Most of them didn't have time to do that. Now the situation is we've got 15 buyers, but there's only one house. And so 14 of the people are not going to get it. Well, after you've gone through about 10 of those where you didn't get it, and then there's a potential claim here for a commission, you might be looking at pursuing that because that's the only avenue to money that you've got right at that time. So okay. A market like this, we're seeing, I think, more arbitrations on procuring cause than we have in other markets.
Yeah, so in other words, I guess one of the final things in this is the fact of, you know, it's the fact that the marketplace drives a lot of these, can drive a lot of these issues. You know, I mean, as time goes by, I mean, something can be become very important for a while and then kind of go away because the market changes, right?
That's correct. Yeah.
All right. You know, we only have a few minutes left. I just want to ask if you could take a minute and, you know, we've talked about a lot of different things, and if you could just, you know, give us, you know, a few pointers or a few things that we as my students, if you will, would need to know in order to properly serve their clients and also keep themselves out of trouble so they're not standing in front of the judge with their checkbook writing checks to the client. If you could share just a few things that you think would be important.
Well, probably the greatest thing that that I could share that would keep people out of trouble is make disclosures all the time. When I was managing offices, I would have associates come to me and say, you know, there's this issue and I'm asking, you know, I'd like to know, should I disclose? And I would say, yes. Now, tell me what it is you want to know, but the reason that you're asking me is all the proof that I need that you need to disclose it.
Okay.
Because what happens is they come to me wanting me to tell them that they don't have to disclose it because they think that if they do disclose it, it might make the buyer reluctant to purchase the property. Well, if so, then obviously that makes the definition of something that materially affects the value or desirability of the property in the eyes of the buyer,
right.
And that is something the law requires you to disclose.
Okay.
So I just tell people disclose, disclose, disclose.
Okay. And they're doing all this disclosure stuff, you know, and the thing that always concerns me is the fact that we have, you know, by the time we get done with these transactions, I mean, I haven't taken the time to stop and count it, but, you know, I mean, you know, we're talking about inches thick of contracts and escrow things and all kinds of things that I have to sign. How do we make sure that when we disclose something to the client that besides using a great big sledgehammer and saying pay attention, how do we make sure that they realistically understand that what we're saying, this is something you need to pay attention to, this is really important. You know, the dishwasher does not work, yes. Or the roof leaks, you know. I mean, what can we do to make sure that they're paying, so they don't come back later on and say, well, you didn't tell me that, you know.
Well, that's the problem, is that they can always come back later and say, you didn't tell me that. I think there's two important things in that. One is always make sure the disclosure is in writing, always make sure they acknowledge receipt of it, and always make sure that they have dated when they received the notice.
Okay, so you give them the disclosure and then they sign, date, and you give them a copy for their records and you keep a copy for your records.
That's correct. Because I have had a case that we ended up in litigation where a disclosure was given to the buyer. They signed it, but they didn't date it, and then later on they claimed they didn't receive it till after close of escrow. So you always want to make sure that it's dated as well as being signed.
Okay. Well, I want to thank you very much, Dave. You know, you've spent quite a bit of time here today, done a lot of work, and I want to thank you very much for taking the time out of your busy day and coming down here and sharing your years of experience and knowledge with us, and I want to thank you very much.
My pleasure. Always willing to help.
Okay, bye-bye.